The new constitution will the need for a balancing act. Moral integrity in the political class is a paradox that India has continually struggled with, while on the one hand the electorate demand moral rectitude in a political class. There has, on the other, been has a prevailing picture of a criminality privileging the political class. The proposed constitution, one hand, and 13th Amendment Bill 100, 13th Amendment Bill 2025, that was introduced in the Lok Sabha on August 20, 2025, is aimed at filling this vacuum by providing a condition under the minister, chief minister, and even the prime minister must either resign or automatically to be subject to removal if they continue to be in a custody even after a consecutive period of the 30 days in a crime that carry a maximum punishment of 5 years or more of a imprisonment. On the on the surface, the action appears to be an discursive initiative toward enabling clearing politics. It touches upon the disturbing fact of a corrupt leader in a custody holding on a power of situation that has made people lost trust in a governance. But there are a political pitfall and a constitutional quandaries that lurk beneath its foundation. For this bill is resist on Article 75, 164 and 239A of the Constitution, which deal with the appointment and tenure of a minister in the Union, state and delegate respectively, while Article 75, 164 and 239AA5 mandate that ministers shall hold office at the pleasure on the President of India or Governor. This pleasure has been judicially interpreted within the bound of constitutional morality and legal prosperity, as in case such as Shamsher Singh and versus State of Punjab and Nawab Rabia and etc. versus the Deputy Speaker and ORS Judicial pronouncement. The Supreme Court of India in S.R. Bomai versus Union of India underscored the role of a constitutional morality as a guiding principle, thus pronouncing that a democratic institution must be nurtured through integrity and accountability. Later in the Manoj Narula versus Union of India and court directly addressed the ethical dimension of a ministerial appointment, warning that individual with a serious criminal charge should not be entrusted with executive power. Although the court stopped short of mandating authority removal, it clearly signaled that morality intrinsic to the constitutional framework to bill therefore draw strength from the pronouncement scheme to give a legislative form to what has long been a judicially recognized moral imperative. But this will be very emission. Maybe it's a chill hill. The most glaring issues concern the principle of the presumption of the innocence, which form part of the right to life and liberty under Article 21 to equate arrest and detention with ground for a removal without a conviction or even the framing of a charge, risk undermining This foundational constitutional value section 83 of the Representation of the People Act concern the disqualification of a member on the conviction of a certain offence. In this case of a Lily Thomas versus Union of India, the Supreme Court held that the lawmaker only upon conviction immediately disqualified the 3 month window to file an appeal and continue as a legislator, while also struck down, thus providing jury jurisprudential support for stringent accountability even before the existence of bill. Here it is important to note that disqualification beginning only when some is convicted and not when someone is arrested or detained. The problem is compounded by the bill's reliance on executive direction through the insertion of clause 5A after clause 5A of article 75, clause 4A after clause 4A of article 164, and clause 5A after the clause 5 of article 239A of the constitution. Minister can be removed on the advice of the prime minister or chief minister, but automatic removal kicks in if such advice is withheld. This dual mechanism politics the process. A prime minister may assert allies for 30 days, while a hostility chief minister may allow revival to fall by the automatic rule instead of the insulting governance from a partnership. The bill risks embedding accountability in the shifting stance of a political cultivation. Inconsistency in the treatment. The inconsistency in a treatment between the legislator and minister further complicates the matter. Member of a parliament and member of the state legislature face a disqualification upon a conviction under the Representation of the People Act by a contract minister under the bill would be forced to resign or mere detention. This creates a paradoxical situation wherein a legislator convicted of corruption may be technically continued as a minister until disqualified under the act, while a minister only under the arrested would be pulled out. The asymmetry may be appear to elevate the standard to executive office, but it also undermines consistency in the constitutional treatment of a public officer. It risks determining capable individual for accepting ministerial pomp, knowing that they face harsher consequences than their legislative peer on the basis of an unproven allegation. There is also a problem of an involving door because the bill allows reappointment once a minister is released from a custody. There would be a cycle of a registration and a reinstatement depending on the piece of legal proceeding. Imagine a chief minister who is arrested and detained for 30 days, who is focused to resign but later released on a bail and promptly reinstated by the governor. The state would have endured week of a political uncertainty with little to gain. The unethical accountability. Such an instability may not only make governance but insensitive. Practical legal maneuvers where a political actor use the law either to manipulate executive office need for the more newest model. None of this is the urgency of a reform. The rise of a criminalization in the politics is a stark reality, according to the comprehensive analysis by the Association of Democratic Reform and National Election Watch. A bill 544 543 winning candidates in the 2024 general election to 251 members of the parliament. 46% had a declared criminal case against themselves, up from a 43% in 2020, 34% in 2014, and 30% in 2017. 50% increasing over the 15 years. At the bluntness of its approach risk undermining both the principle of fairness and the stability of a governance. A more now newest model newest model would better serve the constitutional goal of a clean politics without eroding democratic safeguard. One pathway could be the link removal, not to be arrest but instead to judicial milestones such as the farming in the check by the competent court. This would ensure that only cases that pass initial judicial scrutiny trigger resignation, filtering out of frivolously or politically motivated arrested. Another safeguard could be the establishment of the independent review mechanism such as the tribunal of a judicial panel to examine whether the conditions for a removal have been met. This would be prevent executive overreach and ensure impractical application. Similarly, instead of the outright removal to the law could be provided interim suspension of the ministerial function during ongoing trial, allowing the government to continue without a compromising 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 compros compros compromising promising compros promising promising accountability. Most importantly, the bill should be refine its scope to apply only the offence involving moral turpitude and corruption rather than casting a year of imprisonment, which could include relatively minor criminal conduct. In the Constitution, in some, the Constitution 113th Amendment Bill 2025 takes out of a significant normative position that a citizen might welcome as a forceful stand against corruption and criminality, but its formulation irritates the inherent tension between safeguard democratic deliverance of justice and urgent demand for ethical governance. Unless the Joint Parliamentary Committee (JPC) carefully recalibrates in corrupt due process and institutional check in the bill is with the JPC, it is going to transmute constitutional safeguard into an instrument of a political exclusion, testing the delicate balance of India democratic experiment for in this long run power without